Right, good.
My trip was absolutely amazing. It was an eye-opener. Yeah, and I actually was very lucky. I got to meet somebody there that is heading up mediation in Cambodia. Ken actually gave me the introduction, so I reached out to him. So Savat is his name, Savat Mas, and we had a great conversation talking about mediation and talking about where it was in each of our countries. And, so it was lovely to kind of, even though I was it wasn't a work trip or it wasn't a trip specifically for mediation, but then, I don't know, mediation is kind of part of who you are. It's not really work, is it? So we had a great conversation.
Yeah. No, Savat used to come for I think 2 years back, he used to come for some of the meetings, but I think language was an issue. Was English, was it a bit of an issue with him? So
yeah, and it doesn't help because I talk quite fast, so it doesn't actually help. So I had to kind of slow myself down, but he's doing great work, in very difficult circumstances. So I've great admiration for him.
So I think, but what we need is a separate session to discuss this. Right now, we have to go for this because, like I said, back to back. So mediation legislation, the how, what, when, where, which, who, why of it. Andrea, now the problem that is happening is not enough time for me to put up my website and say, please go there. So I'm not going to do that. Go to mediatorvikram.com. You'll find information. Oh no, I need to put that up. I need to. No, why I need to put it up is because the magic in mediation episodes for you and Michael are coming up. So let me just put this up, that this is the new series which has started. We've done with Ken and with Mr. Panchu from India. 2 episodes have happened. Michael is coming up on Thursday and Andrea is coming up on Friday, right? So that's what's coming up. Otherwise, let's just go straight for mediation legislation. So Andrea, it's all yours. You want to talk about yourself, although there's enough. There's an Andrea playlist on the channel also where you can find all those things that she's come for. So Andrea, it's all yours, please.
Mine. Okay, so I suppose I'll start firstly by saying I don't have a legal background. So I have no legal training. I'm a mediator, a pure mediator. So I suppose when I'm explaining the Mediation Act here in Ireland, it's not from a legal background or a legal mindset. So it's very much on how it affects mediation, how it affects the mediator, and how it affects the participants in mediation. So I'd first of all give an overview. Am I okay to share the screen, Vikram?
Yeah, please.
So
well, that's a good thing, Andrea. That's a good thing that you aren't, because look, legislation is not made by lawyers. They're made by legislators who don't even need a qualification to be a legislator. Yeah. That's a good thing. Whoever you trust, that person can be a representative. So in that sense, it's a good thing that people who actually practice it should have their views on how things are. So
sorry, Vikram, I'm just trying to see why I don't know why this is not coming up. Just bear me 1 second.
No issue at all. But at the same time, if you
sorry, Vikram. I thought I had this up.
No, take your time. So all I'm saying is now there are 50 plus speakers from 30 plus countries, and tomorrow we have that workshop. So Parvati, tomorrow there's a workshop at 6:30 India time. Of course, we'll have your session before that, but you should participate in the workshop also. So just an idea of discussing what we discussed through the symposium and kind of a model mediation law kind of a thing. So that is the idea behind that.
Vikram, it will be very difficult for me to participate also in the workshop, but I'll let you know. I will send you an email.
Yeah, we'll fix up a time. Yeah. Yes, and we can see, but we'll tight shows to start. Yes.
So the Mediation Act came into Ireland in 2017. Now, it actually didn't come into play really until 2018. Now, there's obviously a lot of work went behind it. And I suppose for me, I would see it more as a starting point. There's certain flaws in it and that need to be addressed and need to be looked at and maybe changed in some way. And that's my own personal opinion, nobody else's. So that's my thinking on it. So I'll just give an overview of it. So It was December 13, 2017 that it was signed, the act was signed off, but it actually was January 2018 before it came into play. So the objective of the act is actually to promote mediation and really to encourage people to look at an alternative form of dispute resolutions, and I suppose to move away from the court system as being the first port of call. There's things that are taken into consideration in the Act around the role of the mediator, cost elements, things around, whether it's legally binding or non-legally binding, the role of the solicitors in this, the role of the courts, and various other things like that. So, I mean, it's broke up into numerous different parts. So I'm going to fly through this. Have I a half an hour, Vikram? Is that it?
Yes. Now you have 20 minutes left.
Okay. So the idea is that the purpose of the Act is to facilitate an environment where disputes can be resolved through mediation rather than through civil proceedings. There is to be a mediation council, a body set up to help, I suppose, promote mediation, to provide a governing body for mediators, and also to provide maybe a code of practice and possibly somewhere where participants that use mediation can kind of link back to if there's something they're not happy with. That is still in the process. So the council still hasn't been formed yet. There's a massive amount of work went on at it, around it last summer. There was a number of different structural committees that were sent out. I was actually on one of those. And what was actually very, I suppose, encouraging about it was that it had mediators from community sectors, mediators from families, mediators from workplace, mediators from commercial, those from the legal background, and also interested parties, other than mediators. So really, it was a great brain bank of ideas and views to bring together. So there's been a couple of stumbling blocks. So that's gone back now, and there's, it's gone back to government, and there's a few people kind of looking at things. I'm sure I'm explaining that very simplified matter, but it is a step in the right direction. So the Mediation Act is broken down into 6 parts. So basically, the first part is about really kind of what it's generally about, what its purpose is, what mediation is. And part 2 is kind of in around that as well. Part 3, this is, really interesting, is around the obligations of solicitors, then the role of the court, then the mediation information sessions, and the amendment of other acts. Okay, so it's broke down into 6 sections, then each section, like any other kind of piece of legislation, has loads of subsections and, A, B's and C's and 1, 2, 3 and everything else that you could get bogged down into. So I've tried to simplify it as best I can. And I've just looked at some of the sections that as mediators are, maybe has, I suppose, changed maybe somehow in the way we perform our mediations, or will influence us, when we do kind of move forward with the legislation. So in section 8, there is about the role of the mediator. So one of the things is, as a mediator, you have to tell the participants if there is a conflict of interest, which makes sense. We would have been doing that anyway, that kind of way. But it's just, I suppose, it's in an official document now. I'm a member of the MII, and we have our own code of practice and ethics that we adhere to. And a lot of this would be in that anyway. So we need to, so if somebody approaches me for mediation, say if it was a couple who are separating and they approach me for mediation, one of the first things I have to do is send them out what my qualifications are, what my experience is, and also my practicing certificate, which is something I always send out by, just to kind of give them an idea of who you are, what you're about. I'd always send out a bio, a little small kind of little bit of information about where I kind of do most of my work, and maybe other qualifications that I have that are outside mediation. So then code of practice. So this links up to section 9. So the idea behind this, one of the purposes of this act is that all mediators would assign to a specific code of practice or a code of practice of a different body. That section 9 is the formation of the council. So the formation of the council hasn't happened yet. So therefore, I'm a member of the MII, so I have signed up to their code of practice. There's other mediation organisations, representative bodies, and their members would be signed up to their code of practice, so there isn't one specific code of practice. So again, this impartiality, integrity. So this is about what, would be referred to as neutrality. Not one of my favourite words.
Not using luckily that word is not used. Yeah, luckily that word is not used. We're very happy. We don't want to go there. It's very nice that we haven't got that word there. Yeah.
So the word they use within the Act is impartiality and integrity, right? And I think integrity should go without saying, but it's important that they put it there. Impartiality, my word is multi-partial that I use, but impartiality, I suppose, I even think impartial nearly emphasizes that you're indifferent to what happens, where I think when you're multi-partial, you have a vested interest in some way to the parties, and only a vested interest in providing the space where they can negotiate, as opposed to, giving them, making decisions for them or pushing them in a certain direction. Time is another thing. So one of the things that's mentioned in Section 8 of the Act is that mediations are carried out over a reasonable amount of time. Now, there's no guideline to what that reasonable amount of time is, but it is stated that it is done within a reasonable amount of time. The other thing, when I meet with participants, is that they would sign an agreement to mediate. Okay, one of the things that would be in the agreement to mediate is that they're aware of the rights to have independent legal, financial, or other types of advice, so that when they're in mediation, they are fully informed. So that has to be reiterated kind of throughout the process. Sometimes, now this is my own personal thing on it, sometimes I feel they have to be aware of their rights, and that they can have legal advice and they can have financial advice. But I think it has to be done in such a way that they are not left with a doubt that in somehow you're not good enough to help them to come, or that they're not good enough to come to this agreement. So it really is just about advising them to get the proper background information so that they can agree with all the knowledge, and I suppose we're in the best possible space for them. Mutual agreement of parties, so therefore that they both agree to go into mediation, that nobody is forced to go into mediation, that is voluntary. Now, which would be different to say the way I would operate is I would never make proposals to participants in a mediation. I might, help them explore things or help them brainstorm, help them reality check. I personally wouldn't make proposals, but in accordance with the Act, they are entitled to ask for the mediator to give a proposal. Now, the proposal is not to be, I suppose, pushed on them in any way, but the proposal then is it's an option for them to make a mutual decision on. So all agreements that they make is by mutual agreement and self-determined, but they can ask for a proposal on request.
But one thing, Andrea, that you've got when you said impartiality and integrity, I think that other part that goes with that section is treat the parties fairly. There's lots in that. I mean, it's just
huge amount. And that's why I didn't do every section. Because I know we've only a short bit of time. Section 10 is around confidentiality, which is, I think, is really important, because especially when it is court ordered, or if it's something that goes back into the court, that what makes mediation, one of the things that makes the ingredients that makes mediation work is that it's confidential, that people have a space where they can have open, honest dialogue, where it's not going to be used in any way as a weapon or as something in the future, So I think protecting that confidentiality is really important. And I think as mediators, we have a responsibility to do that. Now, don't get me wrong, there is limitations of that confidentiality if there's going to be a possible harm to somebody else, or if there's something, really kind of that's going to cause danger, or, so there is those limitations around it. But generally, we're talking about something that's not too complicated, and it's just, a conversation between two people, maybe the lives they've lived together, or between two work colleagues about their experience. I, as a rule, don't take many notes when I'm doing mediation. I use flip charts. You'll see the flip chart here behind me. I use flip charts a lot of the time. So they're my notes, and I'm able to write up the agreements, from the flip charts. I would say most people would find it very hard to decipher my flip chart notes. Now, however, in accordance with the Mediation Act 2017, there is a but to the confidentiality. So if the mediation agreement doesn't make necessary provision in regards to, say, a family situation where, there's something to do around providing for the children, the family home, certain things like that, well then, or there hasn't been full disclosure of information, well then the court can order that confidentiality to be broken. Now, this whole thing about full disclosure as well has caused a little bit of issue, in that the Act doesn't necessarily say that's for family mediation. The Act just says that there has to be full disclosure from both parties or both participants, or maybe they workplace, be they commercial, be they, community, whatever it is. So it doesn't break down, what area we're talking about when we say full disclosure. So that has caused a little bit of an issue, in that, people want more clarification around that. So who has to give full disclosure? Why they can see the merit of that when you're working in family situations, but maybe it's not, it might necessarily be necessary when you're working in commercial mediation, or workplace mediation, that there's a full disclosure. So there's little things like that, but there, I really think it's a starting point. I think these are things that you come, it doesn't matter what you build in life, what sort of framework, what sort of, even say, Vikram, with what you're doing here, you learn as you go along, and you build and you change, and, you just recognize that this is a really good starting place. But there are a few things that need to be maybe looked at. So
from the work I'm doing, or from the legislation point of view? Which one?
No, but from the legislation point of view.
Okay.
But also, no matter what we do, like no matter what new project we take on, when we started, by the time we're halfway through, we've learned a lot more. And on reflection, you can look back and say, okay, actually, this might have worked better, or that might have worked better. And I think that goes with everything. Yeah. That's why there's amendments to acts. There wouldn't be an amendment to a piece of legislation if everybody got it right first time. So this is section 11 is about the participants, is about the self-determination. Okay. And it's also about, it looks at whether, so according to this act, sorry, I'm not explaining myself very well. According to this piece of legislation, a mediated settlement agreement is legally binding unless otherwise stated. Okay, so if you work with two participants or three participants, multi-party, if you're working within a mediation, you draw up a mediation agreement and everybody signs that mediation agreement, and there is no mention of it being legally binding or non-legally binding, it is considered a contract, a legally binding contract. If parties or participants don't want that to be a legally binding contract, well, then the mediator must state in the agreement, the settlement agreement, that this agreement is not legally binding until such time that is signed, it is reviewed by a solicitor, or that it's, if it's, say, for separation and they're going for a decree divorce, that they can, until that time, it's not going to be legally binding. But you must state it in the settlement agreement. So if it's not stated in the settlement agreement, it's legally binding. If it is stated that it's not legally binding until, well, then it's not legally binding until. So does that make sense?
Yeah, perfect.
Okay, so this is probably, I think this is really good. And maybe solicitors would disagree with me, but in section 14 of the Act, there's an obligation on solicitors and barristers, but I just had a quick look at solicitors, in that they must advise their clients of mediation. So they have to, when they come to them with, whether it's to do with separating or it's to do with a civil dispute over something, they must inform them about mediation, and they must give them some information on mediation. But they also have to sign a sworn affidavit to say that they have explained mediation to the parties, they provided information, and then they decided, yes, they would go with mediation, or no, they wouldn't. But the solicitor has to sign an affidavit to say that he has given them information or has told them about mediation. Okay. Now, the court can also invite parties to mediation. So if that's section 16, so if there's a case going on and the judge is kind of looking at this and he's going, you know what, mediation should have been tried here, or, you know, we should consider mediation here, he can actually advise them or send them to mediation. So to allow them kind of to consider if mediation would be an option here. The other thing that he can do is he can adjourn the court case so that mediation can happen. So there can be, you know, the court case can be put on hold to allow the participants to try mediation. So I think that's, I don't know your views on it, Vikram, about court-ordered mediations.
You know my views about it.
So, look, I think what's really great, and I can see it happening here in Ireland, is that the judiciary are really looking at mediation and looking to see how mediation could work, and looking to see how a lot of, especially around family disputes, how a lot of those family disputes could be, you know, moved towards mediation first and the court second. But I think what we need to do is make sure, with that encouragement and with that push towards mediation first, that it must be done in a mediation mindset. So it's to try and get that shift between the, I suppose, trying to get a problem solved in a different way and actually trying to get a problem solved from a mediator's mindset. And I think it's different. You know, I think there is a slight difference between those. But it is very encouraging. We have the family mediation services here in Ireland. They're growing all the time. So it is providing a greater space for families to go into that arena as opposed to go through the court system.
But Andrea, what you need to do is yesterday's session with Gabriela and Jimena from Ecuador. You must watch that. It's Ecuador. Things are really good. I mean, good things are happening in mediation, and there is no court mandated mediation there. And it's really successful the way it's operating. And I mean, it's being used by the government also for their, I mean, there are certain things they use it there. So I think it has to be looked at. Have a look at it. We'll discuss it on the 19th, whatever thoughts come to you. So yes, that's some, I think now we are at that. Okay, little concluding kind of thing, please. You have.
Yeah. So really then it's the mediator's report to the court. So I said I was kind of focusing on how it was for the mediator. So we, as we are legislators in this, you know, around what is required of us to give a report to the court. So really, you know, it's just to say that mediation took place. It's just to say that, you know, whether it was successful or it was unsuccessful. Now, what's interesting within this act, there is a provision on it, and I just want to say, I can't remember the number now, Vikram, as I said, I'm not a legal background, that the judge can consider costs based on somebody's refusal to go to mediation. That's interesting. And again, that worries me a bit around the voluntary end of it. If we're going to punish somebody for not going to mediation, Are we pushing them into mediation as a tick box exercise rather than be fully engaged? And then there's another part of it where you kind of think, well, sometimes you get them into the mediation room and they see this process of mediation, which might be completely new to them. And actually sometimes getting them into the room helps it work, and it works brilliantly. So, you know, I'm not sure about this one. You know, I'm a bit, you know, I don't think you should be punished. You know, there should be a monetary punishment for not going into mediation in any way. But look, that's where we're at. I mean, the intention behind this act is to promote mediation, is to encourage mediation, is to provide a framework for people who are taking part in mediation so that they understand the process and so that they're protected in some way in the process. And also, I suppose, for the mediators, so that they have a professional kind of body behind them. Now, I would be part of the Mediation Institute of Ireland, but, you know, to me, then we go back to integrity, you know, so if your integrity is there, are you not professional, you know? So anyway, that's my thinking on it. So I suppose concluding on the Mediation Act 2017 here in Ireland, there's probably people, I know for a fact, people a lot more qualified than I am to speak on this. What I've given you is a quick guideline and how it kind of affects us, you know, on our day-to-day job. I mean, as you know, you have mediators who are working with families who think the agreement is legally binding because we have been told in the act it is legally binding. And then you also have mediators who are kind of going, well, look, this agreement can be affected by other acts and other laws that are out there. And if I put this as a legally binding agreement without being checked over by a solicitor, is it infringing on any other legal aspects? So it's caused a bit of confusion around kind of the whole family end of it. And then in workplace, I mean, people in workplace don't necessarily want it done in such a stringent process. And then for others, they do, because they're following a framework within their organization where somebody makes a complaint or somebody goes to mediation and what's the next step, and they need to show that they followed a process. So I suppose there's discussions that could go on forever around this, Vikram. It feels very short. Sorry about that. I feel.
No, I know I put you on the spot because definitely you don't want to talk about legislation, but you have to do it. But Teresa's here and she has lots to tell us, so we'll have to get her in. But the important thing is that what I missed in the whole thing, is there a particular qualification required for mediators? Is there anything there?
No, there's not,
okay,
Vikram. Well, now there's, you know, most mediators would have to have, at the moment in Ireland, you could sign yourself up as a mediator and not have any qualification, you know, not be part of anybody. That is what they want to change. They want to change it that there is regulations around who's mediating and who's not mediating, that they have at least a certain standard of qualification, that they are signed up to a certain code of ethics, that they are signed up to, I suppose, an agreed framework. And I suppose that's part of that when you send out your information, that you provide the participants with information on your qualifications, information on your experience. And a thing that I always do is send out a copy of so every year I renew my practicing certificate. So I would always send out a practicing certificate with my mediations. So in some regards, it is there, but it's not written down in the legislation around kind of what exactly the qualification is.
Perfect. Oh, and hopefully Andrea will fight that out and she won't let that happen. Let anyone be a mediator. So let's get Teresa. There is no time because the next session, this is back-to-back kind of situation, this 30-minute thing. I don't know. Okay, thank you very much, Andrea. Always a pleasure.
You.
And we're seeing you on Friday on Magic in Mediation. And of course, Michael's coming up on Thursday. So and tomorrow, 19th, yes, tomorrow, the workshop. So please, all right.